Hi everyone, I'm Annalisa from C.A.C. Global Solutions. We're aircraft management specialists, and today I'd like to present you with a very special project. As a series of interviews, Bret Peters and I had the opportunity to speak with the Deputy Director of Civil Aviation for the Isle of Man, Mr. Colin Gill. We discussed the history of the administration, the structure, the regulation, and the different aspects and pieces that have to be in place in order to manage and register aircraft under a flight operations, airworthiness, and maintenance perspective. We also talked about transition aircraft, as the registry also supports this kind of projects. The intent with this interview is to share knowledge about the regulation and the services provided by the Aircraft Registry of the Isle of Man. We'd like to thank Mr. Colin Gill, Deputy Director of Civil Aviation, the Director of Civil Aviation, and all the people of the Isle of Man Aircraft Registry that made this interview possible. We are grateful for the opportunity to have had this conversation, and we're sure you're all going to enjoy the content and the information shared in this interview. Enjoy, and thanks for watching. Hi everyone, it's Annalisa and Bret. We are here today with a special guest. His name is Colin Gill, and he's the Deputy Director of the Civil Aviation for the Isle of Man. Colin, welcome, and thank you so much for your time and for meeting with us.
Well, hello, Annalisa, Bret. Thanks for the opportunity to talk to you guys at C.A.C. Global Solutions about the Isle of Man Aircraft Registry. We really welcome the opportunity. Thank you.
Thank you so much. So we would like to jump in the interview and with yourself. Tell a little bit about yourself, your role in the Civil Aviation Authority.
Okay, so as you said, I'm the Deputy Director of Civil Aviation for the Isle of Man. My day-to-day role is to lead and manage the routine day-to-day safety, security, regulatory activities of the Isle of Man Civil Aviation Administration. And a key part of that organisation is the Isle of Man Aircraft Registry. I've been in aviation all of my career, originally an air traffic controller. Then I became an aviation safety manager. And for the last 17 years, I've specialised in safety regulation. 9 years at the UK C.A.A. in policy and strategy. And I've been here as the Deputy Director since 2016.
Oh, wow. It's quite a career.
Yeah, I love aviation. It's a passion. Ever since my first flight ever was in a two-seat de Havilland Chipmunk as an air cadet, and I actually took control all the way up through working in the military and flying in the backseat of a Harrier.
Oh wow!
And so really, aviation is my passion, and I've particularly enjoyed the last 9 years specialising in business and corporate aviation regulation.
Nice. So do you still actively fly at all?
No, I don't. I'm one of those partially completed PPL guys. The scariest moment in my life probably was downwind solo in a PA-28 and not being happy with the approach to a 9,000-foot runway in a PA-28. So I went around and then found myself downwind again and thought, you know what, I really need to be on the ground. But I just, it didn't work out, the scheduling for flying training with my circumstances. And I really wish I'd finished. But I love flying whenever I can and just enjoy aviation in and around.
Yeah, well, for sure.
So what can you tell us about the authority, with the structure, how many people work for the authority?
So we are an integral part, the Isle of Man Aircraft Registry is an integral part of the Isle of Man Civil Aviation Administration. And that's the organisation that looks after the entirety of aviation safety and security for the Isle of Man. We're a relatively small team, 22 full-time people. We supplement that with a pool of contracted airworthiness surveyors as well.
Okay, so just for me to understand about the authority, when was it founded?
So the Isle of Man Aircraft Registry was established in 2007, and it was set up as a cost-neutral regulator to directly support the business aviation industry, both on the island and globally. And the basis was that at that time, back in 2007, business aviation aircraft were invariably registered with the regulator of the state that they're based in. And the industry perceived that those big state regulators' core focus was airlines. And they sort of felt they were a lower priority and needed some focus and priority to recognise the importance of business aviation in global economics, and how important it is to facilitate their continued operations. So the Isle of Man came up with an innovative plan to have a specialist business corporate aviation register that is founded on the highest standards, but also provided friendly, business-like, efficient services. And the new registry with the M nationality seemed to be exactly what the private business corporate jet owners needed. And I think in the first year, expectations were that there would be about 12 aircraft registered. By the end of that year, 51 had registered.
Oh,
And
wow.
since 2007, since the start of the registry in 2007, we've registered over 1,300 aircraft. We're sixth largest private corporate business aircraft aviation register in the world. So the aim of the registry is to provide safety with service, uphold the high regulatory standards that we're proud of, but whilst providing outstanding support and excellent customer service that's tailored to the business community's need.
So the Isle of Man administration, or the Isle of Man register, that's autonomous from the UK register, is that right?
Totally separate in organisation and delivery. We obviously have colleagues, and we know people in each organisation, and actually it comes together under the UK signatory of the Chicago Convention. So the UK signatory to the convention extends to all the territories under the protection of the UK. So all of the overseas territories, the Crown dependencies, and the UK, what we call Main, as you know, as UK C.A.C, collectively as the aviation authorities of the UK under that signatory, come together under the UK's Department for Transport to ensure that we're maintaining our compliance with the Chicago Convention. But in practical purposes, day to day, I mean, organisationally, we are totally separate. The Isle of Man is independent from the UK in its governance. The Isle of Man was never part of the European Union, whereas the UK was and retains assimilated EU law still, whilst it progresses since Brexit. But we are a standalone state from the UK, separate from the EU, separate from the UK.
Okay, interesting. I'm just curious also, for oversight of the authority, state oversight, would the UK be responsible for that then? And would they do audits on
Yeah, it's a very good question. Because we are working under the UK signatory, we have got obligations to not put the UK government in breach of their signatory to the convention, to the Chicago Convention. And so there's a memorandum of understanding between our two jurisdictions about how that works. We have a very close working relationship and a lot of collaboration and trust with Department for Transport. But we feed into the UK's signatory to the convention. We have our own pages and sections on the online framework of the ICAO USOP compliance, as do all the other territories. We maintain our compliance directly into ICAO and then work with Department for Transport to keep them assured. We are subject to ICAO USOP audit, just as any other state. We were audited as part of the UK audit in 2009. And we also have a process of ensuring that we have external independent audit as part of our quality assurance processes that help to assure the Department for Transport that we are maintaining our obligations under the MOU and maintaining high standards under the convention.
Thank you.
So about the authority, what kind of services the authority provide? I think partially you answered this question a little bit. You were talking about corporate business aircraft. Do you provide also commercial services?
So the aircraft that we register may only be operated for private, corporate or aerial work purposes. Commercial air transport operations are not permitted. The register is set up to focus on private, corporate and tailor our services to those. And we maintain that focus. Whilst we provide services to private corporate aircraft, as I say, we also register and oversee aerial work, and we offer a service to transitional aircraft, aircraft between leases that are parked or being reconfigured. Our core focus in those private corporate aircraft is large and complex aeroplanes and twin turbine helicopters. But we also, at our discretion, register aeroplanes with a maximum takeoff mass between 2,730 and 5,700 kg and single turboshaft helicopters. We will register any aircraft of any weight to an Isle of Man resident, but we're not focusing on doing light recreational aviation. Our focus is corporate business aviation. But for Isle of Man residents who are on the island and wish to register their light aircraft with us, we offer that service as well.
I'm just curious, you mentioned transition aircraft. So would these be aircraft that are known to be going on to an onward state, or we talking also, do you provide a storage service? I know some authorities don't do that.
We do both. We will offer a service to register an aircraft, and if that's all the client needs and they're parking it and storing it, the aircraft is registered. Of course, if they wish to start to operate that aircraft, they'll have to bring it out of storage and reach an airworthiness standard. And of course, to be issued with a certificate of airworthiness, we need to be satisfied as to the airworthiness status of the aircraft, and we'll survey the aircraft. So we do have storage aircraft.
Yeah, I have a question before we go into registering an aircraft with the Isle of Man. So I think it's important to understand. So the authority has its own set of regulation. Is that correct?
Yes. So we have established primary legislation, enabling legislation in accordance with the Chicago Convention that give us powers to regulate, to generate operating regulations, secondary legislation that give us powers, enforcement powers, access powers. We then publish our operating legislations that we call secondary legislation. They're the technical legislations that meet the requirements of the annexes to the Chicago Convention. And we supplement those with means of compliance and guidance material, which are contained in what we call registry publications. So our legislation is our own, fundamentally to meet the requirements of the Chicago Convention. And we have the ability to cast our eye at other best practices around the world and decide whether we want to follow others or not. But we will look at UK, EASA, the FAA, NAV Canada, Australia, and look for good best practices and work out what we think is appropriate for the Chicago annexes to the convention to meet that compliance and give guidance that makes sense and is appropriate to corporate business jet operations worldwide.
Okay, so actually the Civil Aviation Administration of the Isle of Man can actually issue a new rule or amend a new rule by itself. It doesn't need any...
Yeah, so that's a good point. We are regulator and legislator. Okay. So key part of my role with a legislation manager is to develop, draft, consult on our legislation. Clearly, we then, as an embedded part of the Isle of Man government, we use our Attorney General's office to ensure legal process. And then we take our legislation through the Isle of Man legal system to be enacted and put onto the statute.
Okay, so just to clarify, so is it the Civil Aviation Administration, is it part of the Isle of Man government?
Totally. We are 22 full-time staff that are directly employed as civil servants by the government. So we are like a state regulator. We're not some sort of private company. We work directly within government, and that means that we're not under economic or commercial or profit pressure. We're a cost neutral registry. All of our income goes to the government treasury. We aim to always cover our costs and not be a cash cow. We're not a profit organisation. We're here to provide high quality, efficient, good safety regulation as a cost neutral service to the benefit of global business aviation. Yeah,
good, fantastic.
I'm just curious. So with the any revenues generated by the administration, they go into the we would say the government coffers in Canada. So all of the funds for the operation of the administration, that's part of the annual budget of the federal budget of the Isle of Man. Is that right?
So we have that's correct. The Isle of Man Civil Aviation Administration has a budget that sits within the tiered budgets of government. That's integral to that as a division of a department within government. We are self-sustaining. We cover our costs. Anything that's left over goes into the government, not into a private company that might be contracting and providing services for a government. We're a government regulator, but we behave and act with the business-like customer focus of a private company, but with the credibility and quality of a government organisation, with no cost, profit drivers whatsoever. We need to cover our costs, which we do through our charges, our scheme of charges to our clients, which we believe are competitive and appropriate charges. It means that our decision making is driven by safety and good regulatory common sense, rather than some sort of profit target.
Right. Yeah, makes sense. Okay, so now into the juicy part. So how easy is it to register an aircraft?
As long as the applicant fills in the form and provides the right documents, it can be incredibly fast. It can be within a day. We work through email, online, and our online system, our customer interface system, which is a web-based system. There's no hard copy papers that we have to wait for or send out. And it amazes me that there are some major state regulators where people still seem to have to turn up in person with paper and sign and wait. Everything we do with a global clientele is done digitally. We were one of, if not the first, one of the first ever international aircraft registries to go fully digital way back in 2015. So all of our certificates are digital, and that has worked incredibly well. They're annotated appropriately, and we've had no problems or issues, for instance, with ramp inspection. That has worked incredibly well. And so to register an aircraft can be very, very easy. The admin is not very complex as long as the right documents are in place, the right forms are filled in, and the evidence is provided all add up. So if proof of ownership can be provided to acceptable standard, can be incredibly fast. We deal with clients as they come and turn them around in a managed, appropriate, considered way. Now, if somebody wants to register an aircraft with us and it doesn't have the required documents and the required evidences, it won't be registered. So a lot is fundamentally, we make it as easy and efficient as possible, and it's down to the client. The same with deregistration at the other end. It can be incredibly fast to do a deregistration because it is an administrative function. There is some technical analysis, but it doesn't require hours and hours of poring over compliance documents, which is different where you may be issuing an approval on the basis of safety analysis or assessment of an aircraft's airworthiness, which is a different matter entirely.
Right. What about eligibility to registered aircraft with the Isle of Man?
Yeah, that's a good question. So there are limits and there are criteria. We call it qualified ownership. An aircraft needs to be owned by an undertaking or a body, an organization, a company that's been incorporated in, and here's the list, the Isle of Man, a member of the Commonwealth, a state within the European Economic Area, Switzerland, Hong Kong, Japan, China, USA, or a person. So an aircraft that wants this to be owned in the name of a person, if they are a Commonwealth citizen, a national of an EEA state or Switzerland, or what we term in law a British protected person. So there is a tight criteria there. It's not global, but it is quite broad, particularly where you look at the state of the Commonwealth, the state of the European Economic Area, and then the additional countries that are listed as acceptable to us.
Mm-hmm. And of course, then the majority of the aircraft on the register would be offshore to the Isle of Man.
The vast majority of our aircraft are owned and operated by entities outside the Isle of Man. We have aircraft that operate in all four corners of the world, all continents. We're a global registry supporting international general aviation. The Isle of Man is not a big island for the operation of aircraft. There's a small number of aircraft on the island. We see the Isle of Man aircraft sometimes coming into the island, but the vast majority are operating around the world, and we regulate them wherever they are around the world, be it online, telephone, or in presence to do aircraft surveys as necessary.
Right. Okay. So having said that, I'm presuming that there's really no obligation for an aircraft owner, a registered aircraft owner, to ever present the aircraft on site at the Isle of Man, is there?
No, we would do travel to them as necessary. If an owner chooses to fly it to the Isle of Man to present it to us for one of our oversight activities, it's within their gift. But we 100% of the time since the registry has operated, we travel globally to survey and oversee the aircraft that are registered with us. Obviously, the aircraft that are based on the island here, we're based here at the airport. We nip out, go around the other side of the airport, and see the aircraft.
Yeah. Okay. Perfect. So when it comes to type certification, are there any limitations to register an aircraft? And some other civil aviation authorities, they actually accept type certification from other states. So is that something similar?
Yeah, our process for type certification is very, very simple. In accordance with the allowances of the Chicago Convention, we directly accept type certificates issued by a number of major states. that acceptance requires no technical evaluation by us. Again, in accordance with the expectations under the Chicago Convention, we directly accept the type certificates issued by EASA, FAA, Transport Canada, ANAC, and the UK. And that is a very quick, efficient process because it is direct acceptance. We are not state of design or manufacturer. We use the ICAO provisions as they're set out for small states of registry to define which type certificate compliant states they accept, and we add them to our type certificate acceptance list.
The administration, they don't issue their own cover acceptance for that type. They just simply accept that type. But there would have to be application made by the type certificate holder for acceptance by the administration, right?
Yeah, the process we use is that we maintain a living list of type certificates accepted. And once that type certificate is accepted, it's on the list, and an owner of an aircraft that wants to register with us, if they see that it's on the list, there's no type certificate acceptance needed. We've already done it. If it's not on the list, they submit an application, and we go through an admin process to validate that that type certificate is genuine, has been listed, which of course is incredibly easy because of the type certificates are explicitly listed on the websites, but we do a checking process and a reviewing process, and then we add it to our type certificate acceptance list. So there is a process of checking that we've already accepted it, and if not, applying for acceptance, and then we go through a process of accepting and publishing that acceptance on our public-facing website.
Right. So now quite a number of aircraft have type certificates accepted by a number of different authorities that you'd already mentioned. So is it the administration's position that they would accept, for instance, if I brought a Boeing, I could have it on the EASA type, FAA type, or Transport Canada type?
So we'll accept the type certificate that they wish us to regulate it under. We quite often will do change to type certificate at the request, state of type certificate compliance at the request of the owner. So we're not accepting a certificate that's accepted by another state. We're accepting the original state's compliance. So if somebody's got a 777 transitional aircraft that's an FAA TC and they want to keep it FAA TC, we take it FAA TC and we ensure its compliance against that type certificate. If they want it to change to an EASA TC because the aircraft management company, as this transitional aircraft, see it potentially going to a European AOC next, then we will survey the aircraft. They will do all the prep work. They will do all the compliance documents to make it an EASA aircraft, and they will then demonstrate that compliance to us. And on demonstration of evidence that they have met that type certificate change, we will issue the C of A under the new type certification. So a change of TC is facilitated at the request of owners and operators. It's not ever driven by us. They must have a TC from the list, and if they want to change it, they can. We go through the process of then validating and assuring ourselves that the type certification has been achieved. For some aircraft, as you know, you probably know, it can be incredibly fast. The gap, the delta is very small or nil. Some others, my airworthiness specialist always tells me the story about the stick shaker. I can't remember the aircraft type, but an FAA one needed a stick shaker and an EASA one didn't, or vice versa. So we're experienced and skilled in working with the requirements of those states of TC, and are not just focused purely on we regulate EASA aircraft, for instance. We regulate EASA, FAA, Transport Canada, ANAC. There are some restrictions on ANAC, but you can see them on our website, and UK, of course, since they left EASA.
So you are partially answered the question. So the administration actually can issue export C of A.
Oh yeah, invariably, we find vast majority of aircraft that are deregistering, and deregistering is a natural process for any aircraft, not just transitional. Ownership circumstances change, people get newer aircraft and trade up, people's circumstances change in the business aviation world, and they need to register elsewhere. So deregistration is not seen as some sort of we've lost a client, why's that happened? It's a very natural state in business aviation, and of course exactly what you expect in transitional aircraft. So we facilitate deregistration with high customer standards just as much as registration. The vast majority of states of register seem to still want to have an export C of A. We can't quite understand why, because it doesn't really offer anything to the receiving state, unless that receiving state were to issue a C of A on the basis of what we'd done, which we would never do. We don't follow that at all. We insist on surveying our aircraft to support a certificate of airworthiness, regardless of what it's had, what it's come from, be it brand new out the factory or secondhand moved on. So what we will facilitate export C of As to our clients that want them because their new state of registry need them. We will do that backdated to the last survey, so export C of A dated to the last survey without having to resurvey, because that is a statement of on that date at that time. If they need something newer than the last survey as a date, we will insist on a survey to issue an export C of A. For transitional aircraft, a lot of this is compressed, and their initial survey can also be for an export C of A. So we do a combined survey that achieves the aims of both, and it will be a C of A with an export C of A all in one. But as I mentioned, for aircraft coming to us, we don't see that the export C of A that we receive is a mandatory essential item. What we want to know is the airworthiness, continuing airworthiness status of that aircraft. Now, an export C of A is nice if they have one. If they don't, do they have a current C of A? When was it issued? When was it last surveyed? If they don't have one of those, well, what's the airworthiness situation? Where is it? Has it been subject to a preventative maintenance program? Has it been stored properly?
Yeah, this is a topic that we touched on our webinar about the transition aircraft. We said to our attendees, always check if an export C of A is needed or not, because it may not be needed from by the importing authority. Also because the importing authority has to go through the process of anyways check your aircraft for compliance and airworthiness for issuing the C of A. So yeah, it's a kind of a funny document, the export C of A, definitely.
Yeah.
Well, another thing about the export C of A, a lot of exporting authorities, I mean, it's incumbent upon the exporting authority, and this is a funny one with the ICAO convention. It's supposed to be that the exporting authority ensures that the aircraft meets type for the importing state. But as a Transport Canada inspector, there's no way, if I'm exporting an aircraft to South Africa, I'm not conversant with the requirements there. So again, it's actually incumbent upon the importer, so the owner, whoever, to make that determination. So, but we rely on them as regulators to go through that process and tell us whether the importing authority will accept it or not.
That's right.
And if not, what conditions do we have to put against the export?
Cape Town Convention. Can you talk briefly about this convention and how that is translated for the administration?
So the Cape Town Convention was ratified by the United Kingdom and then extended the ratification to include the Isle of Man, and that was done in 2018. So since 2018, we've been fully operating under the convention, accepting applications to record ADIRAs and processing our activity around the convention as the Aircraft Register. We always had a register of aircraft mortgages, and we've retained that mortgage register as well. And so clients have a choice as to whether they wish to utilise the register of mortgages, Cape Town, or invariably both. Most owners seem to want to use any tool available to them to give them as many legal protections. But fundamentally, those two processes ensure our clients' financial interests are safeguarded, and gives control over the potential deregistration of the aircraft and guarantees to the lender.
Right. So I'm sorry, for those that might not be real familiar with the Cape Town Convention, if you could just elaborate a little bit about what exactly it is and how it works.
It's it's probably our least favorite piece of legislation as a safety regulator because it has nothing to do with safety. So I'm speaking as a bit of a layman that has to process what we call a DERA aspect. Cape Town Convention is all about protecting the rights of financiers to the asset they've loaned against, so that a movable asset can't be lost, flown away and hidden somewhere, and the bank has lost the asset they've lent against. That's a very layman description. Cape Town, the vast majority of the content is all to do with remedies for recovering such assets, and it's very complicated and it's nothing to do with us. But there's a very small part of the Cape Town Convention that has a process for recording something called a DERA, which is an abbreviation, and it starts with irrevocable, I can never say that word, deregistration, etc., etc., etc. Fundamentally, it means that the person that's lent, the organization that's lent the money, has a right recorded with us, and we are legally prohibited from deregistering that aircraft without their consent. So the aircraft can't move states without them knowing about it and their consent. Mortgaging or registration of mortgages is very similar in principle. There are different remedies and different nature of effect. But fundamentally, our process and our focus and our knowledge is about ensuring that somebody who has a call on that asset through their loan, etc., is their rights are protected, and there are steps to go through before we would deregister the airplane.
Correct me if I'm wrong, but it not only protects the financier from having their asset deregistered and placed on a different register without their consent, but it also allows them to take control of that asset from whoever they've offered control to, and it may be registered under that entity within your administration, within your register, but now something's gone wrong and they can take control of their asset again.
That's correct. There are principles and allowances that enable that to happen.
So getting to the practical part of this of managing aircraft. So when it comes to an operator, does the operator have to have an approval, a flight operation, private approval? Do they have to have a continual worthiness organization? How does it work?
So probably start, I guess, by setting out what we expect the registered owner to do and how we work with an aircraft operator. As part of registering any aircraft in the Isle of Man, no matter if it's a little small Cessna 150 or a Boeing 777, the registered owner is required in law to appoint an aircraft operator, and the aircraft operator shall be accountable for the safe operation and management of the aircraft. And all the operating rules are actionable on the operator. So the law will say the aircraft operator shall. The aircraft operator shall. The choice of the operator in accordance with principles from ICAO of managing and overseeing international general aviation. The management of the operator is the choice of the operator is the choice of the registered owner, and we take the nomination and record that operator as the person nominated. We do not approve the operator, because to approve the operator, you're stepping into commercial air transport type levels of oversight. Annex 6, Part 2 does not require the operator to be approved. Large and complex aircraft in the ICAO system put requirements on the operator. So we have an operator in our law for all of our aircraft, and they are the person that we regulate day to day. So there are many and various blends of international GA. There could be an owner, operator, pilot of a Mustang, and all three roles are one person who's lucky enough to own, operate, fly a Mustang. We are very experienced at working at the other end of the scale with large fleets of aircraft. A corporate operator of 10 aircraft with an established flight ops airworthiness department working under their own operator, working for the owner in support of their global industry. And there are many and various in between, single aircraft or multiple aircraft, where the owner decides to contract the services of a professional aircraft operator, aircraft management organization. But fundamentally, the operator is nominated by the owner. We accept that nomination and we work with the operator. The operator is then required to nominate two particular key roles. One on airworthiness, the nominated airworthiness technical representative, and one on flight ops, the flight ops representative. And those two representatives take delegated responsibility for the operator for the day-to-day interface with us on those key issues. So all being well and all is going okay, we work primarily with the nominated airworthiness technical representative and the flight ops representative. If things start not going quite right and we need to escalate and deal with problems, then of course we'll escalate to the operator directly. And we copy the operator into many of the routine communications. So that model seems to work very well for us. What we need to do, though, is recognize that there are many shades of grey of international general aviation to reflect the many and various structures and sizes and scale. And what we want is to see something that's appropriate, proportionate to the size, scale, and complexity of the operation. And so what a corporate operator of a fleet of 10 very large business jets will need is going to be very different to what the operator of a single Mustang may need, but it's got to be appropriate, it's scalable. And that's what I think makes working with business and corporate aviation so exciting. One size does not fit all, but there are many and various blends of solutions and ways to manage aircraft. And the same, we talked about transitional aircraft earlier. So we know that investment companies own large airliners and lease them to airlines. So the owner is the finance institution. They will sometimes, because of the uncertainty as to when it will nominate themselves as the operator. So they're accountable. They will quite often invariably then nominate a ferry flight company to manage the operation and the movement of that aircraft. Sometimes they'll actually nominate them as the operator. But again, one size doesn't always fit all. We need an operator. If we will work with the operator, we'll also work with a ferry flight company that's doing work for the operator. And it's not for us to dictate the solution. If it doesn't appear to be working proportionate to the size, scale, complexity of the operation, we'll have a good conversation about it. And we'll highlight that this just doesn't seem to be working. How are you evolving? What do you need to do to put in place an appropriate structure? And we find the industry are invariably very receptive to constructive and open conversations about. A lot of our operators have got growth plans, moving from 2, 3, 4 aircraft to more aircraft. And we work with them at the early stages to say, so how are you going to grow? What does this mean for your organization? How are you going to make sure that you can move from a single operator who's the safety manager as well as the pilot to when are you going to start now thinking about and how are you going to manage setting up a safety department? And so again, that's exciting to see the various blends, and it takes a regulator, I believe, that understands what they're regulating to work collaboratively with the industry to find different solutions and then share. So it was really good a couple of years ago going out to one of our operators that are in Africa. They're operating some business jets, and they also operate DA-42s doing aerial work, and seeing how they operate and learning lessons from them and sharing best practices from seeing an operator of a fleet of King Airs in the UK operating corporately versus the operator of a fleet of small business jets that are used to support an airline, moving pilots, spares, engineers corporately in support of the airline activity. So if there's an AOG 737 in Italy and they need to get an engineer and some spares to it, these aircraft are on our register operating corporately. So we can see good best practices and share those appropriately without breaching any confidentiality about different models and ways of how does somebody operate very effectively a small business jet and somebody new who might need benefit from some advice and guidance. So it's an exciting industry with a lot of blends of different size and scale.
Yeah, I love this because this is exactly our approach. What we're trying to do with the book that we wrote and the webinars that we are doing, the videos that we are putting out there, is just share the different experiences that we had to grow together.
Yeah, absolutely. I mean, both of us, we try to focus mostly on solutions and collaborative efforts because, as you say, as a regulator, I've been into, I don't know how many companies over the years, organizations, everything from single pilot, personal aircraft operation to flight schools to airlines and just seeing the different ways that people can do things. And sometimes it's things you just never thought of. And other times you go, why are they doing that? It's an interesting, there's never a dull moment. So.
Indeed.
Yeah.
So we were talking about the operator, weren't we? And I think there's also a question there about then approvals. So so we've got the operator established. They've got an ATR and an FOR, and then we're into, well, what sort of approvals do we give? But that's focused on what approvals are necessary for the operation of the aircraft. So obviously, certificate of airworthiness. Permits to fly in appropriate circumstances with appropriate limitations, the aircraft maintenance program approval, modification, repair approvals, for particular circumstances to give approval for an operation with a known defect. Again, we use appropriate evidences for that to make sure that that very specific operation is acceptable in those circumstances. And then you're into the flight ops approvals. There's a wide range of navigation, comms, surveillance, aerial work, dangerous goods, EFB. We offer all RNAV approvals, all weather operations. So it's very much a case of what does the aircraft, above and beyond its C of A, what does it need to operate? Of course, business jets invariably need the wide range of comm, nav, designated airspace, RVSM, etc. And so we issue those packaged and depicted within an operations specification. So very similar to an AOC style. For the aircraft, we regulate the aircraft at aircraft level. Every aircraft has an ops spec that lists its operational approvals. we find that works very well. It's a good way of putting in a binder the various operational approvals that our aircraft holds.
So what about manuals for the operator and for the airworthiness part?
So manuals, obviously there's got to be an approved maintenance program. On the operations side, large and complex aircraft, in accordance with ICAO Annex 6, require a company ops manual, a COM, and the COM has got certain contents that are required by ICAO. We provide a COM template with a structure, and then it's for the operator must compile and produce that. Again, in accordance with ICAO Annex 6 Part 2, that does not need our direct approval. They are to have one. They are to maintain one. We will call it in as and when necessary if required as part of our oversight and enforcement. The manual, which is always required to be called in, is all weather operations. And we provide templates again for those to assist people in the collation. So again, it's very much driven by what is the size scale of the aircraft. The most common manual being the company ops manual, which includes, of course, the SMS as well, but they're not approved for every single manual. There's no approval requirement in ICAO for those, but we have and we do sometimes call one in. If we see a non-compliance or we see indicators of concern, we will ask to see the company ops manual, and we will then regulate it appropriately if it's not meeting the minimum standards for the content.
So under an airworthiness point of view, do you need to see a continuing airworthiness management exposition? How do you see if the person responsible for airworthiness is managing, like, for example, airworthiness directives properly? So
we do not require a CAMO, which is a European construct and is not a global ICAO construct. We have no objection to operators using a CAMO. We require a nominated airworthiness technical representative. And if that happens to be somebody who's a CAMO, that's for the operator to decide. Again, we regulate to ICAO standards for international general aviation. So we have requirements on which classes of person or organization can sign a release to service. We expect an aircraft to be maintained, its continuing airworthiness to be maintained in accordance with our legislation to meet the requirements of the type certificate. And that's why we then do an annual survey for the maintenance of the certificate of airworthiness. And that survey checks samples compliance, ongoing airworthiness compliance. So we will issue certificates of airworthiness for 1 year, and reissue is subject to survey. And survey can be remote using technology, video, photograph, or appropriate scale of technology, or it can be on site. And we offer the choice primarily to the client, to our customer, which one would they prefer. We reserve the right to insist on an attended survey, but our whole premise of remote surveys is that we have means and processes to deliver them to an equal level of compliance as an attended survey.
Perfect. About maintainers, do you recognize maintenance approvals from other countries, or do you have to have a specific one?
No, one of our key benefits, we feel, of being one of many benefits of being registered in the Isle of Man, is that we feel that we're probably providing the most comprehensive repair network in the world. In that, first and foremost, there is no need for a Isle of Man maintenance organisation approval. We do not approve maintenance organisation approvals. In accordance with ICAO principles, we automatically and unilaterally accept EASA UK FAR Part 145. No application is needed for that. So it's embedded in our law and guidance around it that an organisation, a person working for an organisation that has those approvals may sign a certificate of release to service to an aircraft registry in the Isle of Man. That's using the unilateral acceptance process that the ICAO specify. So as well as 145s, we do the same for EASA UK Part M, so Part F and Part CAO, CAO. But fundamentally, no application is necessary. So if a business and corporate aviation aircraft is operating around the world, it's flown across to the United States, supporting global business, and it has a need for some sort of maintenance rectification, it can go to any FAR 145 that's got the appropriate approvals for that aircraft and be maintained. We then also have two other options, and you mentioned license holders. So an aircraft maintenance engineer that is licensed may apply to us to validate his license. And we validate the license and all of the privileges in it. So aircraft maintenance engineer licenses around the world, as you well know better than me, they're very, very different. And you know, an FAA versus an EASA license couldn't be more different. Both of them meet the ICAO principles. And if you work under the bounds of those two licenses, so you've got an FAA license and it allows you to do ABC, we validate that license. If the license allows you to do it, we validate you as allowing you to do it on an Isle of Man registered aircraft. If there's an EASA Part 66 license holder and it allows them to do EFG, and we validate that license, you're allowed to do the same. We reserve the right to put restrictions on those licenses, but that is only done for enforcement purposes, not routinely. So it hardly ever needed, but we have that ability if we want to say, no, you can't do the following.
Okay.
And that allows a licensed engineer to sign a release to service. The final third case, as a short-term solution, normally for unforeseen or unusual circumstances, is that we have the ability to authorize a named individual to do a particular task. And that's limited to line maintenance and defect rectification only. And that is assessed case by case by our airworthiness specialists as to what is the task, what is the skill set, what is it they're asking to do, can that be done reasonably by that person. That may be an engineer, a pilot, a multitude of people. But our airworthiness specialists here look at that task, look at the skill set required and see, but it's only as a short-term solution. We feel that we've got an incredibly flexible approach utilizing what ICAO offer through licensed engineer that's validated by us or the acceptance of those major state maintenance organization approvals.
Right. So now, what with transition aircraft, I've seen a number of aircraft, even with commercially operated aircraft, where they'll go in for maintenance visits at in facilities in Asia or other parts of the world, where they can accommodate the work that needs to be accomplished. Now, they may not hold, you know, it could be Philippines, could be anywhere, and they may not hold FAA approval or EASA approval. So what would the authority or the administration do in that situation?
They need to find somebody with the right approvals that
really?
fit with us. Yeah.
Okay.
So they've really got the two options. They've got the FAA or the EASA/UK 145. If they can't find one in that location to do it, there is the ability for an engineer holding a license to get their license validated by us. So they've got that option. Now that may constrain the variety of options and engineering services that can be provided, but that is, you know, we work within quite a flexible approach, but we recognize that that might be different to some other states who may offer maintenance organization approvals.
Mhm.
We do not, for good reason, we believe. If you're going to issue a maintenance organisation approval, then you do it to the ICAO standard.
Closing the validation license, I have a question. What about pilots? Do they need the
Good
license
question.
validated?
So again, ICAO require flight crew of aircraft to hold a license issued by the state of registration, private corporate, or validated by the state of registration. We don't issue licenses, we validate licenses. That is the norm for smaller states. So we validate flight crew licenses of acceptable ICAO states. That means all the major big countries. There is a bar that is set. We use a criteria that looks at the state compliance levels in the ICAO system. And we validate the license at what I call license level. If the license allows you to fly a certain rated aircraft rating and a privilege on that license, you can exercise it on an aircraft registered in the Isle of Man. So again, a very similar to aircraft maintenance engineer. It's a relatively simple, quick process. Our validations last for 3 years and are not restricted to a particular aircraft registration or type.
Mm-hmm.
They're restricted to the limits of the license that has been validated. So if the license lets you do it, unless we impose a more stringent restriction, which we have the ability to do, but would only be done for enforcement purposes and regulatory enforcement, then you can do that. So you follow the rules of your state of license issuance. That's reasonable, pragmatic, sensible, safe. I think the worst thing you could have is a pilot who has to follow one set of rules for his license issued by a particular state, and then some validating state said, oh, but our currency and our rules are these. Well, if you start doing that, you're starting to be a state of license issuance, and you should issue your own licenses. And if you're not happy with the rules and the privileges of the license you've validated, you shouldn't be validating that license.
Yeah.
So
Yeah, makes sense.
look at the state that's issuing it, accept the state, accept their rules, validate the license. If you're not happy with those rules, don't validate those state licenses. And in the main, that don't validate can be based on major accident that's exposed the safety regulator in that state. That's something that happened in recent years. Or it could be a state that has got very low scores, unacceptable scores on its USOAP criteria, Universal Safety Oversight Audit Program criteria, that demonstrate its effective implementation of the critical elements of a safety regulatory system. So we have obligations to make sure the state that's issued it are appropriate, but we must draw the line about not becoming a state of license issuance.
Yeah. Yeah.
Great.
So I have a question for about maintenance organization, because you said you recognize certain approvals. So when it comes down to release statement, certificate, the release statement, do you have your own? Do you
Yes.
do you want to see your own statement, or you accept?
This is a really good question and a very important point. Whilst we accept those organisations, they are not acting under that approval. We've chosen to accept them on the basis of they've got that approval. We are happy with that organisation, an employee of that organisation working in that system, releasing the Isle of Man aircraft. And the maintenance release statement is ours, published in Registry Publication 9, Airworthiness Management, and it's they must not and cannot release it under their legislation. It's got to be released under our legislation. Otherwise, it's not a release to service. But we have said who can make that statement. But we give very, very clear guidance on those statements. It's a common question.
I would like to to touch on surveys. So you mentioned that you perform surveys. What about surveys about operators? Is it something that you check on the operator when you do the aircraft survey?
So the continuing airworthiness activities of the operator come out inevitably as part of the airworthiness survey. The airworthiness aspects also come out through the year in between, based on occurrence reports or applications for things, or our general interactions in the ongoing maintenance of that aircraft. So the operator aspects relate to continuing airworthiness fundamentally from the annual survey, but whenever we have an interaction with the NATR, be it an application for a modification, repair, a permit, an operation with known defect, whatever they're applying for, or whenever there's an occurrence report that's airworthiness related. So the operator, of course, is responsible for the flight operations side as well. And similarly, the oversight there isn't a scheduled activity like there is with the C of A, because as per ICAO principles for international GA, we don't have to approve the operator or do an audit schedule. So we've got an ongoing relationship in that flight operations will have a meeting with new operators when they're appointed and talk about the operational management of the aircraft and its compliance. They'll talk to the flight ops representative, make sure they understand where to go for guidance, information, what we expect of them. Of course, there's all sorts of operational approvals that are needed to be applied for and reapplied for, the MEL, NAV and COM, etc., and occurrence reports. And that ongoing overview of the operation informs our performance-based oversight of that aircraft. And whilst we don't routinely audit or visit or inspect operators, if all is going well, if we have questions or issues or need to seek assurance, we will do that. And we'll do that by a mix of Teams meeting or physical visit. And that's driven by performance and risk. And we do go and have meetings with operators to discuss how they're managing the day-to-day operation. What are their top safety risks? How are they managing them? Why do they know that they're the top safety risks? So good meetings with the accountable executives on how they're managing safety. And so we do get our feet on the ground when necessary, but it's got to be proportionate, again, to international GA. And we feel we balance that carefully.
Perfect. So we talked about transition aircraft throughout this entire interview. And is there anything that you would like to add? I feel the approach is very much project-based. You actually really look at the project that you have in front of you and you make the determination of the steps that needs to be taken.
Yeah, it's very project-based. And we feel we are proportionate in our requirements in that we alleviate, given the operation of the aircraft and restricting it to certain flights, very restricted flights only, we alleviate from requirements like the company ops manual with mitigations. There are similar processes done by other major states like EASA member states using derogations. But that means that we're proportionate on our requirements. We think we understand and we feel we're experienced in the unique circumstances. We can be very responsive to a repossession. We offer a range of services. We recognise that quite often there is a need for the operator to bring the aircraft to a certain stage of continuing airworthiness and then move it, and potentially ahead of being able to get a certificate of airworthiness. So move it under a permit to fly. For the vast majority of circumstances, that requires a no technical objection from the type certificate holder. So it's done with their review as a project. So quite often the aircraft will get to a standard. We will survey the aircraft before issuing permit to fly. We always insist on a survey before that. So an aircraft can't just register and get a permit and fly somewhere in the world without us seeing it. We need to do a survey. That validates that standard it's reached and that it's appropriate for the permit in those conditions. It will then continue and do the further work and then inevitably get a second survey, which would facilitate the issuance of a certificate of airworthiness, and quite often jointly surveying for an export. So we issue certificate of airworthiness, export certificate of airworthiness, deregistration. So that's a very common situation. We think we're cost effective in that we cap our fees for C of A for as if any aircraft, if an aircraft is over 200,000 kg, the maximum fee we charge is for 200,000 kg. And that makes us cost effective for the very large aircraft, because fundamentally you have to do the same things no matter how big an aircraft is. So we feel we offer a competitive service, but we don't. Our core product and our core offering maintains large and complex business jets, corporate, private aviation. And that is the vast majority of our services. But the two are a good blend, because we learn a lot from working with transitional aircraft, and it informs our expertise and specialism of dealing with sometimes unusual things with business jets. And now we find that there are business jets that are also transitional because they may be parked waiting sale, and we can use principles of airline transitional aircraft to be proportionate, effective, efficient in how we manage those.
Yeah, it's interesting that you just mentioned this, because it's something that we highlighted in our webinar with different scenarios. And one is just, transition aircraft is not just a lessor moving an aircraft or taking back an aircraft, but it's also just an aircraft sale, is a transition from one operator to another. So it's very interesting. So I would like to get your opinion on something. In our December newsletter, we wrote an article about transition aircraft, and we were asking, are transition projects changing the way we manage aircraft? And the reason why we worded this topic in this way is because I remember when I first started in aviation, and I started in airline companies, so very regimented type of environment. I remember my mentors telling me that we don't fly with an airworthiness idea expired. It's a bad thing to do. Only bad people do that. So we don't do that. But with transition aircraft, sometimes you can see aircraft that needs to be repositioned with an expired ID. So this is why the question, this is why we ask the question in the article: are we reshaping the way we manage aircraft? Do we have to have a more, like you say, project-based approach to these type of situations?
I think it's an interesting question, and what I wouldn't advocate is that the fundamental principles of aircraft continuing airworthiness are not broken, and we should stand by them. Putting transitional aircraft aside, it's always been a challenge for a state of registry of private corporate aircraft and state of operator of commercial aircraft to weigh up: is a permit, a special flight permit to fly, is it appropriate? Can the work be done in that location or not? And sometimes it can, but it might take 6 months and you can't really get the spares there. And so you have to be a little bit more pragmatic than that. Certainly, if the work could be done in that location with no imposition and no impact, we have to weigh up: is it reasonable for a permit to fly? One of the benefits of those fundamental principles of continuing airworthiness and the permit to fly system is that just getting a permit off the state of registry is just a start. What about state of overflight? What about state of landing? And that is quite right, and we mustn't ever lose that. So it can't be turned into some sort of easy, we'll fly on a permit. This is an unusual workaround with appropriate constraints and mitigations and limitations. So we have to weigh it up on its merits, each situation individually. And if the client, with the no technical objection from the state of design type certificate holder, which is key to all of this, if they feel and can justify that flight and its movement, and equally are quite happy contacting every single one of those states that they're overflying and arguing their case, then as long, what is safe, as long as it is safe, then it is compliant with the restrictions of the NTO, that's good. I don't think that should shape how we change our approach to continuing airworthiness for other aircraft in other situations.
With the type of clientele that the register caters to, I find that generally they're a good group of people to work with, and that generally they are collaborative and they are welcoming to any kind of comment or input or criticism for that matter.
Yeah.
But having said that, I mean, there's still an aspect of oversight that has to be performed on them, right? And it's a balance. So what I find is most of these people, if they do find themselves non-compliant, it's not because they intentionally went down the wrong road for whatever reason, but rather there seems to be a disconnection or not a familiarity with the different regulations that people are working with right now. Because, for instance, with a register such as the Isle of Man, I mean, most people are familiar with the FAA or Transport Canada, EASA, but when you come onto a register that has its own unique requirements, regulation, whatever the case might be, now all of a sudden they fall foul by accident, by lack of understanding. Do you find that's the case with most situations?
I mean, the point you make about the industry are invariably decent people trying to do the right thing, I totally agree with. There's always people in a community, whatever you're in, that don't wish to be compliant. But the vast majority of people we deal with are trying to do the best they can. Coming on to the non-compliance because of non-familiarity, I personally don't think that's an issue for us, because we don't gold plate and come up with things that we're making up on a whim. I said many times, I've talked about compliance with ICAO and annexes Chicago Convention. That is what we should be all defaulting to support international GA, so that standard of oversight of that aircraft is common across the world.
Colin, last two questions for you. So what sets the administration apart from other registries?
Well, I think everything we've talked about. We feel that we're the register of choice for private business, corporate aviation, and specialist in their needs. We really strive to be pragmatic whilst highly compliant and very customer centric. We're passionate about upholding our international reputation for quality service, but always seeking to provide safety with service. And I think that's what attracts our clients. They want high quality, high standards, but done as an efficient, customer focused way. We can always be better. We're constantly looking to improve and do things better and differently. But we love to support and enable business aviation and fundamentally support safety with service.
Perfect. And where can people find out more about the administration, about you, email, website, LinkedIn pages?
So the Aircraft Registry has got its own website. If people want to go to iomaircraftregistry.com, no spaces, iomaircraftregistry.com. There's our generic email is on that website, but our email address is aircraft@gov.im. You can call us in our office hours, details on our website. And if you're on LinkedIn, look for Isle of Man Aircraft Registry. But we'd love to hear from prospective clients and our current clients, email, telephone, office hours, we respond very promptly.
Perfect.
Perfect.
Perfect. Thank you so much, Colin. This has been great. It's been brilliant. And I'm sure that a lot of aviation professionals out there are going to enjoy this interview very, very much. Thank you very much for your time.
Thanks very much for the opportunity. It's been a pleasure to talk things through with you guys.
The pleasure was ours.
Yes, thank you.
Thank you so much.
Okay.
Okay.
Have a good day.